at boldip.com.
Hi, I'm JD Hoovener, and I'm the founding patent attorney here at Bold IP. It's an honor to spend some quality time with you today to share with you how we do IP law a bit differently than the rest. Bold IP is an agile law firm whose mission is to serve the bold and the brave. That means we strive to serve everyone, from solo entrepreneurs and small businesses to Fortune 500 companies. Bold IP focuses on intellectual property law, including patents, trademarks, copyrights, and trade secrets. Our team specializes in aerospace, healthcare, and software. We have industry-leading experience in those technologies, and we love seeing innovation in those fields. I want to introduce Bold IP, Bold Ideas, The Inventor's Guide to Patents. This book is out on Amazon.com and is available at your local bookstore. Author, JD Hoovener, yours truly. Our firm connects with small businesses and their individual inventors. We help them make that big decision about whether to move forward with that bold idea. Give us a call or send an email and set up a free consult today. Look forward to hearing from you. Go big, go bold. And today we're going to talk about non-disclosure agreements. And for those inventors and business owners that are holding tight to that secret, this is the chance where you get to share it with a third party. But you've got to use a contract and be smart about disclosing that confidential information, which could be patentable or kept as a trade secret, between just those two parties. And this is the contract that you do that with. So, without further ado, let's jump into that document. And I'm going to walk you through some of the key clauses that you might see on a non-disclosure agreement or a confidentiality agreement that you find online. Some of the pitfalls to many of the documents that you find on a Google search or a free document that you get handed down that's maybe 1, 5, or even 10 years old is that some of the language is really not customized to your personal situation. So right from the title, unilateral non-disclosure agreement. Well, what do these words really mean? The titles do count, and when a judge comes in and was to try to interpret the contract, they're going to need to read the black letter. And so unilateral, that means one way, meaning the inventor or the person with confidential information is the only one giving up confidential information. If, for example, you were exchanging information, which is fairly common between businesses, you would need what's called a bilateral non-disclosure agreement. So if you're using a unilateral contract in a bilateral situation, you've got the wrong contract. And so you've got to start right from the square one with what exactly is going on. Who is exchanging information? Entering into the first major clause, identifying the parties here, is critical. Making sure that you've got the right limiting dissemination of which party is disclosing to the other. Alright, so if it is a unilateral, let's assume it is just one party disclosing, it's important to say who is the disclosing party and who is the receiving party, because they've got different roles, privileges, and authorities based on this contract. Right up front is usually the definition of what confidential information really is. And this is a pretty darn good description of what confidential information is. It's a textbook definition, Webster's dictionary type of a definition. Something to note, though, is that this evolves as technology changes. You see software in here. As technology, information management, cloud storage, you name it, whatever's out there in today's technology, that is sort of the ever-expanding realm of what's potentially confidential. And so taking this at face value is dangerous because it may not include all of those potentially confidential information disclosure areas. Down here is a particularly sticky issue here. If there's an exchange of information, whether it be verbal or physical, in person, this should be done during a formal letter, so that it's all disclosed as far as what physical items are transferred and what if anything via verbal exchange has been or will be transferred. oftentimes it's very important to specify what exactly is confidential. What is the substance that's being disclosed? So if it's a secret design for a new sports car, and it's the way the body shape is, okay, just as an example, that is what would be disclosed. Not exactly the picture of the design, but in words, it would say a novel description or pictorial definition of an automobile body. All right, that's what would be here under specific confidential information. And so if there were a breach of this contract and a judge needed to go enforce it, they'd look to this first section that we just talked about, which is general and really covers anything under the sun. If it's actually defined in section 2 that it's all about a sports car's auto body, and the receiving party breached the contract and told another party about it, that's what the judge would look at and say, you agreed to keep this specific thing confidential and you didn't. You're liable. There's lots of different sections here, and I don't think we have time on this bold bit section to go through them all. But what I want to do is have you tune in next time. We'll go through the obligations of the receiving party, look at the property rights between all of them, time periods involved, and what happens in the event of a breach. So these and the others will be on future bold bit sections. So I look forward to hearing from you in your next session. Feel free to comment, exchange, and thanks for joining us on this version of Bold Bits. Go big and go bold.
Go big, go bold at boldip.com.